Well, no. As far as the dentist work that's been done,
Not
it's
according
not
to
been
your
done
complaint.
correct.
According to the complaint that you signed, sir, the dental work was, I don't know, $700 and some odd dollars. The dentist quoted you, the Beverly Hills dentist quoted you $650.
For a root canal.
Okay? And he said he could get a dentist to do it cheaper.
Right, his dentist.
His dentist for $350.
Right.
And did you go to his dentist?
And I went to his dentist he's been going to.
All right, so that was $350.
Right,
So
exactly.
where's the couple of $1,000s come from?
Because of the tooth. That was just a root canal to disconnect the nerve from hurting.
Right.
That was just for the nerve. And so now I had to go and get a tooth, and I'm an entertainer, and the tooth is still not correct. It's discolored, and it's not correct. And for it to be done correctly, it's going to cost me a couple $1,000s.
Well, do you have an estimate for that from the dentist?
Yes, I do, actually. Well, I don't have the estimate actually itself, but I have everything that needs to be done written from my dentist.
Does the dentist give an estimate?
Yeah, he does give it.
Well, let me see it. All right, now, you say that he agreed to pay, then he reneged on not paying. So whether it's $1,500 or whatever, so now you're suing for $5,000.
Well, I lost wages. I drove out to San Diego to file, work, and just now I'm an entertainer. I don't have my original teeth back, and that's kind of sad in a way because, you know, I mean, I had perfect teeth, and I have pictures of my teeth, what they used to look like and what they look like now. You can look at those too if you would like.
All right, now tell me about the party.
The party, David invited me to his party. It was his first fraternity party, so I went with him. I was out there on vacation just for the weekend, and so I went along with Josh and Dave to the party. And he had stopped at 7-Eleven before we got to the party and purchased some 40-ounces MGDs. We got to the party.
40 ounces. In English, please.
Okay, it's a 40-ounce bottle, and I was just letting you know that's what it was, because that's what busted my tooth.
What's MGDs?
It's Miller Genuine Draft Beer. Sorry about that.
Go ahead.
So we got the MGDs, which is the Miller Genuine Draft. We were at the party. Dave had left me because I didn't know anybody, so I let him go around and do his thing. He had a pin on for fraternity that he's new, and so he was walking around, proceeding and doing what he was doing. I was sitting in the corner minding my business, drinking my beer. He came up just excited. He wasn't deliberately, it was a total accidental situation, and he hit the bottle as I was going to take a sip, and it fractured my tooth.
Well, exactly how did he do that?
He just came up excited, "Hey, Paul," like that, and hit the bottle as I was already going to take my sip. So what happens is I get this indentation in my tooth. He looks over and he goes, "It's not that bad, dude, it's not that bad." And I go, "Dave, you don't understand. I can feel the fracture with my tongue." So that morning, the following morning, I went to the dentist, which was in Beverly Hills, and I called Dave, and he had told me he would take care of it at the party, so I felt better at that time. I was like, okay, I know Dave, he'll take care of it. I'm good friends, you know, I thought that was, you know, it was all cool. So the next morning, I call him to get a credit card number. My girlfriend, actually, who's the witness, she called Dave to ask him for a credit card number so that she could get the card. Come on up, baby. So she could get the credit card number from Dave. Okay.
Okay. I spoke to Mr.
Name.
My name is Kelly Hammett. I spoke to Mr. Kramer on the phone from Dr. Lalazarian's office, where we took Paul to get the work done on his tooth because he was in pain because it was split clear up the middle. I called Dave to get his credit card number so we could go ahead and get the tooth work done. When I spoke to Dave, Dave asked how much they were charging. They got the price. Dave says they're ripping you off. If you want me to pay for this, go to my dentist. At that time, we left and went to his dentist in Chatsworth, where I, myself, put down a $100 deposit for them to start the root canal on him. And that's pretty much it.
Okay, go ahead.
All I really need is my tooth fixed. That's all I'm asking for.
Yeah.
And that's all there is to it. That's what it comes down to.
Good afternoon, Your Honor. Before I start, I would like to clear up a few things that Mr. Shortino did say. The 40-ounce bottle that did chip his tooth, he had it before we even left my house to go to this party. We did not stop at 7-Eleven to get his beer there. When the actual incident did happen, I was in a circle with Paul, Mr. Shortino, and a friend of mine, Joe. Prior to the party, however, he had been drinking very heavily at my home. I have my roommate here and my witness, Mr. Joshua Cash. At the time this happened, like I said, I was in the corner with my friend Joe and Mr. Shortino. Someone said some sort of joke of some sort, and I tapped his right shoulder, and his beer was in his left hand. And somehow, he overreacted, and the bottle came up into his tooth. And this was not a fraternity party per se. It was after a night of rushing at the fraternity. It was not on fraternity grounds, to get that cleared up. And I did recommend for him to go to my dentist that I've been going to my whole life. I felt that he was getting ripped off, if you will, at this dentist for $750, because I did call my dentist, and I told him the situation, and he gave me a rough estimate of around $400.
So you agreed to pay for that?
No, I did not agree to pay for it. I never agreed to pay for anything.
Kramer, Mr. Kramer.
Yes.
So far, you sound like a very intelligent, rational young man.
Thank you.
Let's try to keep it that way.
Okay.
Judge Judy will continue in a moment.
You...
Singer Paul Shortino wants his friend David Kramer to pay for the tooth he broke on a beer bottle.
He would not have called you if he didn't feel that you were responsible. You would not have said to him, "You're getting ripped off, go to my dentist."
I felt
and then speak to your dentist about the price, unless you felt that somehow, some way...
I felt my friend was getting extremely ripped off by a dentist in Beverly Hills. That is what I was doing. I was trying to help him out and not get him to pay more than he has to pay. That is what I was doing.
What did you have the conversation with the dentist about?
Because he asked me what I was calling him about. I told him the situation.
What situation?
That my friend had hit a bottle onto his tooth, and there was a little chip. I didn't know the exact damage, and he said he really couldn't give me an exact figure, and I asked for a ballpark figure, and that's what he gave me.
Mr. Kramer, were you drinking at this party too?
I had a few beers, yes.
40-ounce beer?
I did not have 40-ounce bottles of beer. I did not have 40-ounce bottles of beer, but I did have, I would suggest, a 12-ounce glass of beer, probably.
Mr. Kramer?
Yes.
Mr. Shortino doesn't suggest that this was anything other than an accident.
I understand.
The question is, the question that we address in these kinds of proceedings is, but for your actions, would his tooth have been broken? That's what we call tort law. You know, torts. I got an A in torts in law school. So, but for the intervention of either tapping him on the shoulder or, as he said, you sort of put your hands out in front of him and tapped the bottle so that it went into his tooth, but for your actions, his tooth would not have been broken. There's no question, based upon the evidence that I have, that you did, in fact, suffer a broken tooth as a result of this huge beer bottle that you were drinking, sir. Probably at a time when you weren't supposed to be drinking beer. Is that correct?
This is correct.
Yeah, because you were not of age?
I'm not of age. This is true.
So you weren't supposed to be drinking the beer, but you had this big beer bottle and it was near your mouth. But for that intervention, he wouldn't have suffered this injury. So it's not an instance where you were at fault because you did something grossly negligent, but you are responsible. He's not responsible because it wouldn't have happened but for your intervention. Do we understand each other?
No, I don't think we do.
Just a second. He's going to try to explain
I'm going to try to explain. If it was not due to all the alcohol in his system, I believe none of this would have happened. How does tapping somebody on the right shoulder affect something holding in your left hand? I believe due to his inebriated state, this never would have happened.
You were in front of me.
Just a second, Mr. Kramer.
Yes.
I was trying to be kind to you, sir. You're over 21, correct?
Yes.
You knew he was under 21. Chuck! You knew, Mr. Kramer, he was under 21 because you told me that in your answer. Right? That he was a minor. I mean, I didn't learn it. I didn't pull that out of a hat. It was in these papers that you both furnished to me. Now, you said to me that he was drinking at your house before. He was drinking at your house before he went to the party.
I was not at the house when he was drinking. I was at the fraternity. I then found out about the party. I came back. He was the 40.
How did I get to the fraternity?
Here's what.
He was drinking at what house before?
At my house, but I was not present
Just a
at the
second.
house.
You mean your home where you live?
Right. I was not
Yes.
present at the house. He had gone to Tijuana. I live in San Diego. He had gone to Tijuana. I was at the fraternity. He came back. By the time I came back, he was there. There was
He was at your house?
at my house.
Yes.
There was a bottle of tequila and a 40-ounce bottle of Miller Genuine Draft on the
Yes.
coffee table.
Yes.
My roommate, Joshua Cash, was there to let him in, obviously.
Yes.
I then came home from the fraternity. I said, there's a party. We'll leave in about 20 minutes. And that's when we went to the party, and I drove
Just
to the
tell
party.
me. What makes you say he was drinking at your house?
Because I saw him drinking.
Right.
Judge Judy will continue in a moment. Paul Shortino wants his friend David Kramer to pay for the tooth he broke on a beer bottle.
You furnished a minor.
I did not buy the beer
You
or
didn't
the
have
tequila.
Just a second. That doesn't make any difference, sir. I was trying to be kind to you. You furnished a minor alcohol. You don't have to buy it for him. You didn't say to him, you're under 21 years old and you can't drink in my house. I'm going to tell you something, sir. With the same scenario that you're telling me, if he drank at your house and he got into his car and was driving and killed somebody, killed a 5-year-old child, and they took a blood alcohol on him and found that it was above a .10, you know who they would sue? You. They do that now, and they do it relatively routinely in all of our states, sir. That if parents allow their children to have parties in a house, and if they don't supervise them adequately, so that there's drinking at the party, one of those kids goes out and kills themselves or gets hurt in a car, they sue the parents, even if they weren't home, because that's their responsibility. In this case, you're over 21. You knew he was under 21. You had him in your house. He was drinking. So it's not very smart. What I'm telling you is you are responsible for his tooth because, but for your intervention, nothing would have happened to his tooth. And if he was blitzed at the fraternity party, I'm not saying he has no responsibility. Of course he has responsibility. You know, everybody who's 20 and 3 months goes out and drinks because they think they're a big deal. However, he drank at your house. You stopped and bought these 40-ouncers.
I did not stop and buy them.
Who bought them?
I don't know. They were there when I walked in the house from the fraternity.
Where'd the 40-ouncers come from?
7-Eleven around the corner from his house.
And you stopped there to buy them.
It's right on the corner,
Did
right
you-
down the street.
did you-
Oh, no, he went in because I don't have any ID.
But he went in while you were in the car,
Yeah.
drank some more. So,
There was also a keg at the party, too, so they were
But you wa-
furnishing beer at the party.
but you weren't drinking from the keg. You were drinking from one of the 40-ouncers.
In the 40 ounce.
Yes.
That's how
My
tooth was
witness, Josh
furnished.
Cash, can confirm that there was a bottle of tequila and a 40-ounce bottle before I got into that door. I did not buy the alcohol.
Which door?
My door to my home.
I'm telling you, you just told me, sir, you were present in the house, and you just said to me you were present while he was drinking.
I did not buy the...
You don't have to buy it. It's in your home over which you have control. You're not following me.
Well,
You're not following me. It's in your home. You have control what's things that are inside your home. He was a guest in your home. He drank in your home things that were in your home.
the beer and the tequila were not in my home. I did not bring them in my home.
How could you just say to me they weren't in your home? You just told me
They
they
were in
weren't
my
in
home,
your
but
home.
I didn't bring them into my home.
Doesn't make any difference whether you brought them into your home or not. He was drinking in your home. Gotta be careful who you let drink in your house. Gotta be careful
Obviously.
about taking a minor, to a fraternity party where you know there's gonna be drinking. I'm not saying he has no responsibility, sir. I wasn't even going to get into this aspect of the case. I was just, the aspect of the case that was most important to me was, but for your act of tapping him, pushing him, whatever, his tooth would not have been cracked, and therefore you are responsible. Now, all I have is, sir, is bills for one dentist is $700. From one dentist to the other one is $455.
I've made payments on that one that you have right there. The total for the whole bill is right here.
Well, then let me see it.
That was for the temporary tooth that I have now.
Temporary tooth is on the original bill, sir. Temporary cosmetic
the
crown.
plastic. Yeah. And the tooth that I have now is still not correct, which is the porcelain.
Listen, that's not all his fault.
Oh,
If you want to act like an idiot, you have to take partial responsibility.
You're absolutely right.
Your responsibility is you're going to walk
absolutely
around
right.
with a tooth that's not going to match the rest of your teeth.
Right.
That's your fault.
You're right.
That's your fault. Of course I'm right. I'm always right. $1,371 are all these bills together, sir, including the $455 that you paid to the first dentist and the $916 for the next dentist, which includes the crown.
At first, I felt quite sympathetic toward the plaintiff. As someone working in the entertainment industry, where appearance, especially teeth, is important, having a tooth broken would clearly have a significant impact. The way he described the tooth cracking while he was drinking beer made me think it was an unfortunate accident, and his desire for the person responsible to pay for the repair felt emotionally reasonable. However, as I listened more carefully, I began to separate emotion from logic. This was clearly an accident, with no intent involved. The defendant only tapped his shoulder or made a light contact, not an inherently dangerous action. This initially led me to think that the defendant's responsibility was not as significant as the plaintiff claimed. But then an important detail changed my perspective. The principle of but for that action, the event would not have occurred. Even though it was just a light touch, that action directly caused the beer bottle to hit his tooth. From my point of view, this means the defendant cannot completely avoid responsibility. That said, I don't fully side with the plaintiff either. The reason is that he also bears some responsibility. Drinking underage, putting himself in a risky situation, and then tending to shift all the blame onto someone else, including additional costs, such as cosmetic dental work. This makes his claim for several $1,000s feel somewhat exaggerated compared to the original damage. Another point that stood out to me is the role of environment and indirect responsibility. The defendant knew his friend was underage, but still allowed him to drink at his house and even took him to a party. This makes me think that the defendant's responsibility lies not only in the physical contact, but also in creating the conditions for the incident to occur. In conclusion, from my perspective, this is not a case where one side is completely right. The defendant bears responsibility for the direct action that caused the harm. The plaintiff also shares responsibility due to his own behavior and choices. Any reasonable compensation should be based on actual damages, not emotionally driven demands.
What kind of property was this? Was it a house or an apartment?
No, it was a house.
And when did you move into the house?
November 7th, 1998.
Did you have a lease?
Yes.
May I see the copy of the lease? Who moved into the house?
Me and my 2 kids.
Was that all the people who lived in the house?
Yeah, my boyfriend used to be there, but he didn't live there.
You still have the same boyfriend?
Yes.
How old are your 2 children?
11 and 8.
Is he the father of those 2 children?
No.
But he was your boyfriend in 1998? Where does he live?
In LA.
And who does he live with?
His sister.
Right.
Huh?
Right.
Right what?
Just what I said. Right. All right. So you, your 2 children, and your boyfriend were there most of the time?
Well, he always was in LA because it was so far. So some nights he'll come over and sleep over, but mainly he was in LA by his mother or his sister because, you know, it was too far.
Right. Okay. This is not your lease, madam. What
Yep.
you handed me here, at least the first page of it, unless there was another lease,
That's the whole contract from Section 8.
I'm not asking you for the contract from Section 8
Well, that's
housing.
the only lease that I have, because that's how I got the house through Section 8. And that's the only lease that I have.
What was the entire rent that you were supposed to be paying pursuant to this lease agreement voucher program?
It's on one of those pages that's right up in here, 219.
It says the housing subsidy payment is $581,
81.
and the tenant's monthly payment shall be $219.
219.
Now, did the landlord get this $581 himself, directly from the state?
Yes, that's the contract.
Did you get
from
that
Section
directly
8.
from the state, $581?
Yes.
Okay. And she was supposed to give you, according to this, $219.
Yes.
Now, you moved in November 7th of 1998, and when did you vacate?
I didn't vacate till January the 9th when he moved my stuff out illegally.
Just a minute. January the 9th
Yes.
of 2001.
One.
And what rent were you paying?
For the whole, okay, I was paying $219 up until April 1999.
Okay, so up until April of 1999, you were paying what you were supposed to pay.
Yeah, $219.
And then what happened?
And then he said that the rent was going up, that I had to pay him the $620.
When did he tell you that?
That was in, I think it was March, because I have the first receipt that he handwritten right here for the $620.
So you started to pay him $620
Yes.
in
April, here you go, right here.
April of
1999.
in May of 1999. You
April.
said you paid him in
April.
April $219.
Not April, here you go. February the $219, here you go. And this the one April for 1999 for the $620.
Okay. So in April of 1999, you started to pay him $620.
Yeah.
Okay. And did you pay him the $620 from April 1999?
Yes.
Until you, you didn't hear my question.
Okay, I'm sorry.
Did you pay him the $620 each month from April of 1999 until you vacated the house on January 9th of 2001?
No, I paid it from April till October. After October is when the big dispute came about. In November was when he said, don't pay nothing the rest of the 2 months while you're there. See, if I get to tell what really happened, then you'll see why. Nothing got paid in November, nothing got paid December, nothing got paid January. I was supposed to move out January the 21st is when he went in my home on the 9th and removed all my property, put half in storage, left half there.
I don't care about your property, madam.
Okay, well, that's
not
what
the
I'm
subject
saying.
of this
That's what
lawsuit.
it-
I'm only asking you about when you paid rent.
Up
So you
until
didn't-
October.
Did she pay in October?
She paid all but $120 of the $620 that she was paying me.
I gave him $500.
Just a second. But she still was overpaying.
I don't want to answer that question until I present my side of the case, ma'am.
Okay. Well, at least according to you, Miss Lassie, you paid for approximately 18 months. An additional $401 a month.
Yes,
That comes to $7,218,
yes.
which exceeds the limit of this court. You understand that?
Yeah.
Limit of this court is $5,000. Okay, let me hear the story, Mr. Strickland.
On 9/26/98, Chevelle Lasai, she filled out an application rental for that home that we were speaking of. And I thought the application looked good. It indicated that she had a job making $3,800 a month. It also indicated that she was had a voucher program. She had a car, 1998 Mustang, and her social security number was on there.
Do you have a copy of that application?
Absolutely.
Can I see it, please?
Okay, I'll just sample it. Rental application. I felt that it looked good, and we got together. We talked about renting the house. We made an agreement, signed a rental agreement prior to the section or the housing agency, and that's this right here.
May I see it, please?
And I was under the impression that she could pay that amount since she, expressly signed that contract. About a month later, the situation broke down as I got the information from the housing agency that she couldn't pay $1,251 and that they would only allow $800 because she didn't have a job. She was on welfare. And so that struck me kind of odd. So I called her up, went over there, and I asked her, I said, well, they're not going to allow you to have the $1,251, and I thought that you had a job that could to pay over this voucher amount. And so I asked her why did she lie on the rental application. He says don't worry, we're going to pay you. And I said, what do you mean, we are going to pay you? And then at that time, her boyfriend came out and he says, Ken, we really like your house, man. Don't you worry about it. We're going to pay you, you know. I said, well, I don't know about this because, you know, I spent a lot of money getting this house prepared, and I also thought I had got someone in there that was truthful and honest, and that didn't turn out to be. By that time, you know, I felt that this person was living there. Not only that, I noticed that she had 3 dogs, 2 out in the yard, 1 in the house, and they also had a bird, which was strictly prohibited by, you know, the contracts that we signed.
So why don't you evict her?
Because it was a very tight spot for me.
No, it isn't. No, it isn't, Mr. Strickland.
No.
Real cases, real people. Judge Judy. Chevelle Lassie says former landlord Kenneth Strickland overcharged her for rent. Kenneth says Chevelle lied about her qualifications for Section 8.
Listen, were you working at air conditioning?
Yes.
On whatever date you filled out this application. Let's
Yes.
see, you filled out this application
9/26/98.
9/26/98. You were working there?
Yes.
And you were earning $3,800 a month?
Yes, because I was working at Federal Express too during part-time.
Just a second. You were earning $3,800 a month?
Yes.
Why were you also getting a housing subsidy?
I've been getting housing since I was in New Orleans. And I transferred my housing here, and if you work, that's all they do is make your rent go up some or make it go back down. That's all they do.
You mean if you're making almost $4,000 a month, you're going to get somebody else to pay your rent?
You can be on Section 8 and make good money, just that your rent will be higher. You know, if you're not working, it goes down. So then when I wasn't working, it went all the way down. Because once I moved to Palmdale, I wasn't working at air conditioning no more. I got me another job.
Working for whom?
It's a warehouse place.
And how much were you earning there?
I don't have the total figures in front of me.
Well, give me an idea. Were you earning more or less than $3,800?
I was making less.
Did you tell him that you were going to change your jobs?
Oh, he knew where I was working.
Make $4,000 a month, and the boyfriend lives there, too. What kind of work does he do?
No, my boyfriend was not living there. He was not living
All right.
there.
Yeah, right. And your obligation was $200 a month?
$219.
$219 a month. That's a very good deal. Most people these days pay at least
Well,
a
that's
third.
what Section 8
I said to you,
approved it to be, $219.
oh, this is a wonderful America. You can just transfer your Section 8 wherever you go.
Yes, because I have a voucher. I could transfer it anywhere I want.
Yeah, isn't that wonderful? Listen, it doesn't relieve you. You know the score. You're a smart man, right? You sign an agreement with Section 8 housing? Sir. Yeah. And your agreement with Section 8 housing is clear. This is what you collect from us. This is what you collect from her. Her obligation is $219. What you're telling me now is you entered into a side agreement with her that she would pay you more than the $219 if she really wanted the place. Is that what you're telling me? But that's prohibited by Section 8, right?
That is
Ah.
prohibited.
That's prohibited by Section 8. All right, but she still didn't pay rent for 3 months. Any rent for 3 months.
Because Section 8, this is what happened. He called me one morning in November, in 6:30 in the morning, and told me because Section 8 didn't pay him his $581 because he didn't do some work that was done in the house when they came to inspect it, that if I didn't pay the whole $1,200, that I had to get out. I told him I was not paying it. I'ma just move. Went to Section 8, told them what happened. That's when my worker let me know, no, you are not liable to pay what we do not pay him. But he had me under the impression that I was supposed to be paying him the whole amount that they didn't pay him, and it was a lie. And when I confronted him about it, oh, well, that's what Section 8 told me. I said, no, they didn't. You was just trying to get my money. So I let her know I had been overpaying him the rent, and she the one told me to call legal aid to get advice on it, how to sue him to get my money back. And
Did you file tax returns last year?
No. Wait, did I file what?
Tax returns
Oh, yeah,
last year.
sorry. I'm sorry.
How much did you earn last year?
I don't know. It's on the papers. I don't have them with me.
Everybody knows how much they earn.
Let me see. About...
Everybody knows.
It was like 20, 24, 25, something like that. I don't know the exact amount.
Drive a car?
Yep.
What kind of car do you
A
drive?
Toyota Camry.
What year?
1988.
What happened to the Mustang?
I don't have it anymore.
What happened to it?
I sold it.
Well, you were driving a new car, a 98.
I just decided that I didn't want it no more. One of my friends took over the notes on the car. I went to the auction, got me a little 1988
Just a
Camry.
minute. So you were paying out notes on the Mustang in 1998 when you filled out this rental
Yes.
application. And how much was your car note?
With insurance and everything, it was like $451.
A month.
Yes.
So you're paying $451 a month for your Mustang, and you're paying $219 for rent.
Yes.
You in the wrong business.
What you mean the wrong business?
You're right.
I mean, I had help, so I mean, what's the wrong business? I had a boyfriend that was helping me out. So, I mean, what's the wrong business?
The problem is, I got two people playing the system, right? I got two people playing the system, and certainly Mr. Strickland, I mean, his excuse was that he was lied to on the initial application.
No, he was not.
And that's, yeah, he was.
No, he was not.
He was.
I was working
Hey.
at air condition. I wasn't even on the county then.
You are on the county is when you, listen, madam, when the government pays your rent.
Okay, well, you
Listen,
can
listen
work
to me.
and have
The-
Section
I'm
8.
speaking, when the government pays your rent, that means you're taking money from the state because you can't afford to pay your own rent. People who can't afford to pay their own rent don't spend $450 to drive around in a Mustang convertible.
Judge, when I
The
got
mad
to
Miss
Section
Lassie.
8 in New Orleans, I was not working. I transferred my stuff here. You are allowed to work and get Section 8. You are allowed to work.
I didn't say that you weren't, madam.
I mean, well,
I didn't say that you weren't allowed to work.
What
You
was-
are allowed to work and still get assistance if you're not earning enough money to pay for your rent. What I'm saying to you is if you can afford $450 a month to drive around in a new car, then you don't need that much money to pay your rent. That's what I'm saying. You don't get that? No, you don't get that. Now, Mr. Strickland, who filled out this application?
can I see if that's...
Chevelle Lasai filled that out.
Okay. Did you call her employer, sir, to check these references?
I did call her place of employment, and they did verify that she worked there.
For 4 years.
Yes.
All right. Now, Mr. Strickland, let us assume that this is correct. This was not misleading. If you called and verified that she was working there, then she didn't fill out a false application. She may have changed her jobs later. And she did, in fact, have this 1998 Mustang. So why is this false?
Social Security number is wrong.
Oh, you're full of baloney. You're a smart guy.
Okay, I have...
You're a smart guy. What difference does it make if the Social Security number was wrong? What substantive difference does it make? She gave you her name, she gave you her address, how much rent she was paying, where she was working, how much she was earning. You called and verified where she was working. She did, in fact, have the car at the time. So your defense to me initially, at least in your answer, Mr. Strickland, was that she lied initially in her application. I don't see any lies here.
Okay, could I continue then my...
And do it fast, sir.
Okay, soon after she moved in, like I said, the agency said that we signed the agreement, and however, when they had told me that she wasn't capable of paying it, I went to her, and as I say, we talked about this, and at the time the guy came out, he says, we are going to pay it. Then they had 3 dogs there. They had a bird.
I got 3 dogs and a bird. Yeah, go ahead.
And I said, shh. And I told him, in no uncertain terms, I said, because you are breaking the lease, you know, I have to charge you damages on a monthly basis, and that's going to be $451 plus the water, trash, and everything else. And she agreed to do that.
That's not true, Your Honor.
Doesn't make any difference, sir. Sir, you know that the rules state the contract you signed with U.S. Department of Housing and Urban Development are clearly specified that you are not permitted to charge her any more money. Now, if, Mr. Strickland, you say to me that she was going to pay you $219 and that you had an agreement with her boyfriend and you could establish that he was living there, that you had an additional agreement, that he was an additional tenant in that property, I may say, maybe. But you knew that you were breaking the law by overcharging her. You knew that. The fact that she shouldn't be receiving this money to begin with irritates me as a taxpayer. Big time. Big time. Because she says, well, they just transferred from New Orleans to where I'm living.
They did.
Well, she's a
Well,
little
that's
bit
not-
smarter than that,
that's
Your
not
Honor.
Just a second, listen to me. She's very smart. She's got the system worked out fine. She's got the boyfriend who lives there. The two of them work, right? And the total income that they have, on their total joint incomes, they pay rent of $219 a month. And at the same time, I'm sure he has a car. She's driving around in a new Mustang, right? Taxpayers are footing the rest of the bill, $580 a month for her rent that we're paying as taxpayers. So believe me, I understand that she's got it down pat, but you broke the rules. And unfortunately, as unfair as it may sound to me as a taxpayer, you are responsible for this $5,000, which is the maximum that I can award her because she actually overpaid over $7,000 in rent. So I have no choice, sir, but to enter a judgment for the plaintiff for the amount of $5,000. And I want to tell you something. It breaks my heart.
First of all, when listening to the plaintiff's testimony, the tenant, the audience tends to feel an initial sense of sympathy. She presents herself as someone who only paid $219 under a support program, but was then pressured by the landlord to pay $620, eventually being evicted and having her belongings taken unlawfully. From an emotional standpoint, this makes the audience perceive her as a victim of power abuse. However, as the testimony unfolds, that perception begins to waver. The audience notices inconsistencies in her statements. At times she claims her boyfriend did not live with her, but later admits he stayed there frequently. Her income is unclear and her expenses seem relatively high, a Mustang car installment payments. These details lead the audience to question her credibility, even suspecting that she may have been gaming the system to receive benefits. Turning to the defendant, the landlord, he initially appears reasonable when claiming he was misled about the tenant's income. At first, the audience may view him as the one being wronged, but as the case progresses, his weakness becomes clear. He admits to collecting additional payments outside of the Section 8 agreement, which is a direct violation of the rules. At that point, the audience no longer sees him as a victim, but rather as someone who knowingly broke the law. The most interesting aspect from the audience's perspective is the role of the judge. She does not fully side with either party on a moral level. In fact, she criticizes the tenant for taking advantage of the system, reinforcing the idea that the case is not black and white, but rather one where both sides are at fault. However, from a legal standpoint, she still orders the landlord to pay, because his violation of the law is more explicit and significant. In conclusion, the audience's overall perception evolves as follows. At first, leaning toward the tenant, then growing suspicious of both sides. Finally, accepting the ruling, feeling that while it may not be entirely fair morally, it is correct from a legal perspective.